Good morning, I'm Tina Rañales-Cotos and I'm a member of the Business and Property Department here at King's Chambers. Warm welcome to you all. Today's webinar seminar is essentially about the enforceability of post-termination restrictions ordinarily in the employment context. These types of cases, as anyone who practices in this area will be familiar with, are generally fought out in the High Court. So today I'm going to talk about enforceability of PTRs, as I'll call them. And for the benefit of everyone attending, this webinar is a maximum of 45 minutes. It'll probably be a little bit shorter than that. There are various ways in which you can communicate with us. There's a chat function and there's also a feedback form. So any questions, I'm more than happy to field those by responding to the chat function after the webinar, not whilst it's live, or any questions on the feedback forms. My email is also going to be on the slides. So I've put together a series of slides, hopefully just to give you, the audience, something to focus on other than me. And those slides will also be sent to attendees by email after the webinar. So I'm sure there are people still arriving, but I think we'll start, given that it is 9 o'clock. So PTRs, enforceability, it's probably worth reminding ourselves that these types of clauses generally found in employment contracts are prima facie void and they're unenforceable because they prevent open competition. So if you're seeking to enforce a PTR or a series of PTRs in an employment contract, then the first point is that they'll need justification by the party seeking to enforce them. That's generally the employer. And in terms of justification, the test is one of reasonable necessity. So that is what the employer must show in order for the court to enforce a PTR. And in terms of the reasonable necessity test, what is reasonable is plainly highly fact sensitive and context sensitive. So that is essentially the health warning that you need to keep in mind when considering the remaining slides, that each case is highly fact sensitive. Obviously, there may be cases which are on all fours, as they say, with the case that you are having to consider. But bear in mind, no two cases are the same, no matter how similar. And so it's important to keep that context and that fact sensitivity in mind. So what does the court consider when it comes to enforceability and the reasonable necessity test? So when you're looking at a PTR, there is effectively a logical, I would say, 4-stage approach to that process. And it's probably worth reminding ourselves what the approach of the court will be. I've tried to interweave the slides with the most recent cases, and there's quite a rich theme of those cases, including at Court of Appeal level, just to keep your interest up, because obviously those of you who practice in this area will probably be very familiar with the well-worn, well-trodden principles set out in the established cases. So just to add a bit of interest, I'm going to focus on the more recent authorities, which in some respects simply repeat those well-known, well-trodden pathways, although there is definitely a sea shift, and we'll come on to that in relation to certain aspects of enforceability. So here we go, the 4-stage process. So in terms of acting for the employer who wants to justify a PTR, which, as I've made clear, is void and unenforceable unless he or she or it can justify the PTR in question. The first thing that the employer must keep in mind is the need to show legitimate business interests which are in need of protection. I will effectively drill down in relation to each of these stages in a moment, but just as a bird's eye overview, that is the first of the 4 steps in the process. And the second step then is, what does the PTR or the covenant mean when properly construed? So anyone who practices in the commercial sphere will clearly understand that that is a question of construction in terms of the meaning of the clause. The third phase in the process is the reasonable necessity test. Once the legitimate business interests have been shown and that any issues of construction have been dealt with, we then get to essentially what is the nub of the issue in these cases, which is, does the covenant go no more than what is reasonably necessary? It's no wider than reasonably necessary to protect those legitimate business interests, having regard to its proper meaning. And then the fourth and final step, which to some extent has developed far more prominence since the case of Tillman, which we'll come on to, which was some years ago now. But if, in fact, it goes wider than what is reasonably necessary, then the court must consider whether it can be saved, and that's the severance principle, which we'll come on to. I've cited the well-trodden path in terms of the omitting the first case in the four bulleted cases there. So TFS, derivatives and Morgan is usually the authority relied on for those four steps. But Office Angels and, of course, Herbert Morrison Saxelby, which is the seminal case that refers to the reasonable necessity test, is referred to there as well for your convenience. But really, you only need to have a look at Sparta, Global and Hayes, which is a case from this year, which went to the Court of Appeal to essentially derive those principles. So Sparta is really the only case you need to have a look at, and I've referred to the relevant paragraph there on the slide. So let's just drill down a little in relation to those four steps. So the first is, does the employer have a legitimate business interest, or interests in the plural, which require protection? So we can see there that I've cited two cases. They're well-known cases in relation to what legitimate business interest means in the context of PTRs. So the Thomas and Farr case there defines legitimate business interests as some subject matter which an employer can legitimately protect by a legitimate covenant. So it has to be capable of being identified. And there are some well-established categories, which I'll just rattle through in a moment. But to further assist in that understanding, I've referred to the Stenhouse case there, where essentially Lord Wilberforce set out his observations in relation to a legitimate business interest and what it means. And he said that the employer's claim for protection must be based on the identification of some advantage or asset inherent in the business properly regarded as his property, but property there in a general sense, and such that it would be unjust to allow the employee to appropriate for his own purposes, even though the employee may have contributed to its creation. So although the categories are wide and they are not closed, so it's open to an employer depending on their business, keeping in mind this is all context and fact sensitive, to essentially identify anything that comes within that definition of a legitimate business interest. But the well-recognised categories include confidential information, stability of the workforce, client connections and goodwill. But those are generally speaking the categories that one sees being put forward as legitimate business interests, whereby covenants are reasonably necessary to protect them. So the second phase, what does the covenant mean? So this is a construction point. I've cited there the case of Boydell, which again is recent. And it's a case that involved construction issues. And it's probably worthy of just considering the facts a little before I refer there to various principles, some well-known, well-trodden, and others a reminder really of how the court applies those principles when it comes to construing these types of covenants. So Boydell was an interesting case because it involved a very niche business, specifically bile acid derivatives selling to pharmaceutical companies. A fascinating topic at this time of day. So the real battleground in that case concerned a non-compete clause, which are generally speaking the covenants that that tend to get fought out in litigation for obvious reasons. It's essentially the nuclear option preventing an employee going to work for a competitor, as opposed to non-solicitation and non-dealing clauses. So there was a 12-month non-compete, and essentially it was worded in very broad terms, and it prevented the employee from being involved in any activity for any competing business. So not limited to, say, the activity that the employee himself was employed to carry out for the employer. So the High Court granted the interim injunction, but only after severing some of its wording. So Boydell appealed, and the issues at the appeal level were how the covenant should be construed and whether, in fact, it was too wide. Now, Boydell, the employer, argued that the non-compete was too broad and it would prohibit him from working, in theory, from in any pharmaceutical industry, including, he argued, high street businesses such as Boots and Superdrug. Now, the Court of Appeal didn't agree, and they upheld the decision of the High Court. And in terms of construction, what the Court of Appeal reminded us of is the test, bearing in mind that these covenants, on the basis of applications for interim injunctive relief, are being considered not at trial, generally speaking. So the test on an interim basis is whether it was plain and obvious that the covenants were unenforceable. And that would be on the basis of assuming all facts in favour of the claimant employer and having regard to any permissible severance. So bearing in mind that I'm citing Boydell here in the context of construction, I've then drilled down on some of the principles that the Court of Appeal reminded us of. So nothing groundbreaking, but it's a salutary lesson in relation to construction to remind ourselves how the court will approach construction on an interim basis. So the Court of Appeal referred to the fact that it's the natural and ordinary meaning of the words that the court needs to focus on. And interestingly, and again, this is not new ground, but it's worthy of recollection that although it's an interim hearing, unless the facts necessary for construction, so the factual matrix, are disputed, then the court at an interim stage is as well equipped as the trial judge to effectively consider and determine construction issues. Now, on the facts of this particular case, the clause, whilst broad, the burden of the clause was directed to the very specialist activities of the employer NZP in this very niche business. So, in fact, the wider meaning in relation to the group companies was not obviously incapable of severance. So, effectively, the Court of Appeal upheld the High Court's position on severance. And I think the two important points on construction to take away from Boydell, which are well trodden but important in terms of reminding ourselves that as a matter of construction, then the court is to ignore what's referred to as the fantastical. So covenants must be limited in circumstances which the court considers the parties had in their contemplation at the time the covenant was entered into. So, and I've cited Home Counties and Skilton there. That's the 1970 case, which is where that principle is derived from. So ignoring the fantastical, and essentially it's the officious bystander test. Remember that old chestnut. And in essence, if the parties had been asked by the officious bystander at the time of entering into this covenant, did they intend objectively for Boydell to be prevented, say, from working for a high street pharmacy, then they would both respond, of course not. So that's the fantastical test. And then there's also the validity principle in play, where there are two or more, but normally it's alternative constructions, alternative meanings, and they are both realistic. So that's the benchmark. If there are two alternative meanings, but one is fantastical, then we don't need to consider the validity principle. But let's just say that there are two alternatives and they are both realistic constructions. Then the validity principle enables us to be sure that the court will effectively go with the meaning that upholds the covenant because the parties are deemed to have entered into a valid and not an invalid agreement. So hopefully that just gives us a reminder of, when dealing with construction issues, what the relevant principles are. So I said the nub of the issues in these types of cases is usually the third phase, which is whether the covenant is no wider than reasonably necessary. And I say that because going back to legitimate business interests and construction issues, those are rarely the real battleground when it comes to interim relief. The usual pattern of these types of cases is that an employer will lead evidence as to its legitimate business interests. The employee may say that the employer has exaggerated the extent of those interests, but provided it passes the serious issues threshold, which we'll come on to, which is a relatively low threshold, then those matters are generally left to trial. Equally, in terms of construction matters, certainly with these types of cases, whilst it is possible to determine those matters at an interim stage, ordinarily either the meaning is clear or they are matters which require some understanding of the factual matrix and the context, and so they're matters for trial. So as I say, the real issues tend to be fought out in the context of this third phase, which is the nub of the issue so far as covenants are concerned, which is justifying that they are no wider than reasonably necessary. And this is where I've referred to some interesting recent cases on the matter. So the first is Jump Trading International and Verition Advisors. That case went to the Court of Appeal. And in essence, the employee, and in the context of that case, he was a quantitative researcher employed by Jump Trading. Now, his contract contained a rather unusual post-termination restraint. And the issue was what length needed to be justified. Was it void for uncertainty? And was 24 months too long? But just to understand those points, just to turn to the actual covenant in question. So there was a non-compete covenant which was said to apply for the length of any notice period, the length of the garden leave, and the non-compete period itself. Now, the non-compete period was actually a sliding scale from 0 to 12 months, and it was to come in, or it was triggered after the termination date, but as elected by the company, by the employer, within 20 business days following notice of termination. So in essence, here we have a post-termination restraint where the employee could not be sure until that 20 business day period as to what length of covenant the employer would seek to enforce. And the decision as to what length was a unilateral one left to the employer. Now, the High Court essentially considered that this covenant was no more than reasonably necessary, but in fact an interim injunction wasn't granted due to delay. But we'll come back to that point. So far as no wider than reasonably necessary, what the Court of Appeal observed was that there was no difference between this sort of creative 0 to 12 month sliding scale covenant and one for a fixed period of 12 months. But and where that fixed period one expressly gives the employer a discretion to unilaterally reduce it. So the Court of Appeal observed that in effect, it was no different to a fixed period of 12 months. And indeed, all covenants give essentially the employer the option to offer a shorter period. What the Court of Appeal considered was whether or not the High Court was right to essentially say that there was a serious issue to be tried as to its length and whether or not that was no more than reasonably necessary. And the Court of Appeal said it in the absence of it being obviously and inevitably void for uncertainty, then it should go forward to trial. And the uncertainty issue, the employee and the new employer, Verition, argued, arose because of the fact that there was, in theory, a fluctuating scale from 0 to 12 months. And they said that that meant that the clause was void for uncertainty. regardless of whether it was no more than reasonably necessary. And the Court of Appeal said that that was not obviously the position, because there was a mechanism for resolution built into the clause, subject obviously to the maximum permissible period of 12 months. So the void for uncertainty argument didn't succeed either. And the Court of Appeal reminded us that the employer must justify the maximum period at the time the contract was entered into, and not at the time of the election. And it might just assist you to understand that the legitimate business interest relied on by the employer was its confidential information, which it claimed had a shelf life of up to 2 years. And on that basis, the Court of Appeal considered that it passed the test of being no wider than reasonably necessary at the interim injunctive stage. Obviously, whether or not the employer could prove that it had legitimate business interests that had that inbuilt shelf life of 2 years was a matter for trial. So that's an interesting recent case on this reasonable necessity in the context of the length or the period or the duration of the covenant. In terms of the breadth of the covenant, again, keeping to this third phase as to what is no wider than reasonably necessary, I've cited there the Sparta Global case and Hayes, again, a recent case. Now there were 2 separate agreements, and the court was being asked to scrutinise the investment agreement and to effectively grant an interim injunction to enforce its terms. What's interesting about this case is that the employment agreement also had covenants, post-termination restraints. However, the employee had already given undertakings essentially reflecting the terms of the employment agreement prior to the employer issuing the application to enforce the investment agreement covenants. Now, essentially, the employer sought to argue that it needed an injunction to enforce the investment agreement covenants because it offered better protection to it. And I've just set out there on the slide in what ways the employer sought to argue that it gave it better protection. For example, it was for a 12-month period instead of a 6-period non-compete. The non-compete was not limited to activity which competes. So to that extent, similar to the Boydell case. And it was not limited to the kind of work that the employee had done at Sparta. And it was not limited to clients with whom he had dealt. And in fact, went beyond what Sparta appeared to have at an earlier stage considered necessary. So there was some pre-action correspondence whereby Sparta had essentially said that all it needed to protect its legitimate business interests was the employee to adhere to the covenants in the employment agreement. And the employee, having done that by offering undertakings, they then essentially went beyond their position and sought an injunction to protect its position under the investment agreement, which, for the reasons I've bulleted there, it considered what gave it better protection, and of course went much further, which is why this case is a paradigm example of the court considering the breadth of a covenant. Now, in essence, I mean, it may assist to understand that Sparta Global, anyone who knows anything about their classics and will know that Sparta was the alternative city to Athens, and the Spartans were hardy individuals who wouldn't give up. And in essence, the business of Sparta was to place underrepresented groups into employment. And their business model was something referred to as HTD, hire, train and deploy. And in essence, this particular employee was subject to 2 different agreements. And we'll come on when we deal with the balance of convenience, the context of there being different agreements and the way in which the court scrutinises those, and whether the court scrutinises them differently depending on whether they're a commercial agreement in the true sense of that, an arm's length agreement, or whether they are more akin to an employment agreement on the calibrated spectrum, as it were, of these types of agreements in the context of covenants. what the court determined there was that the inequality of bargaining power is a relevant factor at the balance of convenience stage. And in fact, there's a relatively recent case in the franchising sphere that goes so far as to say it is a significant factor when the court comes to determining whether or not an injunction should be granted. And on the facts of this case, the nature of the agreement was more akin to a contract of employment. So it was an investment agreement, but it was closely tied to the employee's employment. And in fact, it only gave them a very small percentage of the shares in the business. And essentially, in rather a damning judgment, the High Court stated that Sparta was unlikely to persuade a trial judge that the investment agreement covenants were reasonable given their breadth. And I think the relevant part of the judgment to highlight is that the court effectively observed that such a clause appears to be stamped with unreasonableness. So be careful what you wish for is probably the summary in relation to Sparta. And then finally, in this phase, the trilogy of recent cases is the Literacy Capital and Web case. I'm not sure I need to dwell too much on the facts of this case, but it's relevant in relation to length and breadth. This was a sale of a business case, straightforwardly, so it wasn't an employment context. However, it related to covenants in a loan agreement, which eye-wateringly had a 10-year nationwide non-compete. Unsurprisingly, the High Court determined that they were unarguably void and unenforceable. They were too wide, too long, and there was no simple and clean way to sever them. So that's obviously the Tillman case, and Boydell was applied there. And effectively, the court observed that protecting the actual business, the subject matter of the agreement made sense, albeit not for too long. 10 years was plainly too long. But protecting other businesses, which is what the clause sought to do, made no legitimate sense because the defendant didn't have any expertise in any or most of those fields. So essentially, it was a clear case of a covenant preventing open competition. So that brings us then to the fourth phase in terms of when a court assesses enforceability. Can the covenant be saved? And I'll just canter through this because it's not really a recent case, but it is a seminal case in the context of severance because it very much resolved a conflict in two court of appeal authorities that had been long running. And those of you who are familiar with what had gone before Egon Zehnder and Tillman will be familiar with the blue penciling test. So essentially, the court must still adopt a cautious approach to severance, but it definitely is part of the assessment of enforceability. So if you're faced with what appears to be a wide covenant, then it's perfectly proper to essentially assess it once any parts that are capable of being properly severed have been severed. That's the approach the court will take now. And what Tillman put to one side was this test about whether or not what is being considered for severance is of trivial importance or a mere technicality. That is no longer part of the test. The blue pencil test remains valid, so that's the test where one has to assess whether what is being severed is simply a removal without the necessity of adding to or modifying the words of what remains. So if you have to add or modify what remains, then it falls outside the blue pencil test and it will fail the severance test. So essentially, Tillman said there are always three considerations when considering severance. There's the blue pencil test, there's the adequacy of consideration for what remains, and helpfully, the Lords in that case essentially said we can ordinarily ignore that stage of the test. But the third stage is the crucial stage, which is whether the removal would not generate any major change in the overall legal effect. So it's not the practical effect, as the employer and the employee may feel it, but rather it's whether or not, once removed, what remains changes the overall legal effect of the covenant. and it's for the employer to establish that the removal wouldn't change its legal effect. And Boydell is an example, a recent example of the Tillman clarification being applied. So those are the 4 phases, and that was a canter through with emphasis on that third stage, which is always what these cases tend to focus on at an interim stage. So I've referred to the fact that we generally consider enforceability of these types of covenants at an interim stage. So I thought it would be worth us just having a look at some recent cases in the context of what the test is for an interim injunction. So on this particular slide, I've cited the American Cyanamid case, which is so well known that often it doesn't appear in the authorities bundle. I'm sure everyone attending this webinar will be familiar with the 3 phases of that test, but I have set them out there because I just want to delve into the more recent cases and observations made in relation to the American Cyanamid test, which of course remains good law, as it were. So you have the 3 stages. Is there a serious question to be tried? Would damages, if there is, the second phase, would damages be an adequate remedy for either of the parties injured by granting or not granting the injunction? And if adequacy of damages suffices for one or other, then in theory, the court doesn't go on to the third stage, which is if damages are not adequate, where does the balance of convenience lie? And I think we can get quite hung up with this 3-stage process, and often the second and third stages are considered together. Nonetheless, I've cited Plannon there, which is a relatively recent case at Court of Appeal level, which refers to the American Cyanamid test. And then the Boydell case, where Lord Justice Bean made the following observations about cyanamid. It remains a case that has seminal status, but he stated that it is neither a statute nor a biblical text. And employment cases, which are far more limited in scope than the case that was under scrutiny in American Cyanamid itself, it may be unjust to stop at the serious issue to be tried. And essentially, Lord Justice Bean reminded us that the statutory test for the grant of an injunction is simply whether it is just and convenient. That is essentially what the court is being asked to consider. And of course, American Cyanamid distilled that into those 3 helpful stages. And the reference to the in Boydell to employment cases being far more limited in scope is in relation to the fact that cyanamid itself was a very complicated patent case. And I mean, it was argued over weeks at High Court level, and even in the House of Lords, as it then was, it took up, I think, 3 days. And the trial itself wasn't, in fact, heard, I think, until about 4 years later, and went on for months and months. So when one considers the complexity of the factual background and the context of the American Cyanamid case, essentially Lord Justice Bean was saying that sort of case is a world away from the type of employment cases that are far more limited in scope, which might mean that it's not fair to simply stop at serious questions to be tried, and the court should perhaps consider the merits at a preliminary stage. And I suppose it's worth reminding ourselves that peculiar to covenant cases, there is authority for the court being able to at least take a preliminary view as to prospects of success at that third stage, the balance of convenience stage of analysis, in determining which course would result in the least risk of injustice. And that's the Lansing-Lindy case, which I've referred to there. And Boydell essentially reminded us that that is permissible. So it's probably also worthy of reminding ourselves that in the context of these types of covenants, the American Cyanamid approach is not suitable in the context of mandatory injunctions. So those are in effect final orders. So there the court needs a high degree of assurance, that's the test there, that the relief sought is appropriate in assessing the course that has that least risk of injustice, which is what the court is doing at the balance of convenience stage. And I've cited Capita and Darch there, but it's Zockel and Mercury that is the authority for that test, the high degree of assurance test in the context of mandatory injunctions. Most covenants are prohibitive in nature, of course, but often in this field, there's an adjunct or an auxiliary head of relief in relation to, for example, delivering up documents or property belonging to the employer. And it's important to remember that in the context of those types of applications or that head of relief, you have to address the mandatory aspect of the injunction and satisfy the court and of the high degree of assurance required. And then finally, springboard relief, which isn't strictly speaking a scenario where the court is assessing enforceability of a covenant. But I just thought it was worthy of setting it out. In fact, by definition, if you're having to rely on springboard relief, you probably haven't got a covenant, or you haven't got one that you consider would be enforced. And because of the nature of springboard relief, which is more substantive in terms of relief, then the court should assess the strength of each side's case without conducting a mini trial. And I've referred to the Forster-Sakama case there that just reiterates that. So just briefly dealing with serious issue to be tried. What does that mean? We probably all know it. It really simply weeds out those cases that are frivolous or vexatious or otherwise demonstrably bad. So one has to show real prospect of success or that the case is reasonably arguable. So the arguability threshold, which we'll all be familiar with from summary judgment or strikeout. So it's not a demanding test. I've referred to Plannon and I've referred to Jump because they're recent cases where those well-trodden principles are referred to. So you can simply refer to those cases. However, I've just noted there that the jurisprudence is gathering around that concept of whether or not it's merely the serious issue to be tried threshold, or whether or not the court should consider a more holistic approach, if that's the word, when looking at the balance of convenience, and particularly where the covenant will expire before trial, and take a preliminary view. A mini trial is not appropriate if it can, of the merits. And then just a few points on the serious issue to be tried from an evidential perspective, because obviously most of you in the audience will be looking to draft evidence to support an application. A few things that might sound obvious, but you do need to lead evidence as the employer on the real prospect of success threshold. You can't have an injunction just because you seek one, and that's the Caterpillar and Crane case, Court of Appeal. So you need to basically focus that evidence succinctly on the various phases which I've referred to, which is the legitimate business interests, any construction issues, and focus on why the period, the breadth, is no more than reasonably necessary by reference to those legitimate business interests that you've led evidence on, and if necessary, dealing with severance. So a few interesting points that might just be worth here raising and underlining. So there is a need for that evidence to support the real prospect of success threshold, even though it is relatively low. A refusal to give undertakings in correspondence is not necessarily to be treated as evidence of a threat or intention to breach. So bearing in mind that you can't have one just because you're asking for one, ordinarily that evidence then has to focus on wrongdoing. You may not have cogent evidence, but you need to set it out at the early stage to show that there has either been a breach or a threatened breach, because otherwise the court won't consider that there is any reason to grant an injunction. So just pointing to the fact that the employee has refused to give undertakings in correspondence isn't to be treated as the evidence of the threat. Something more has to be done or said, which of course is material for anybody there responding on the wrong end, as it were, of a threatened application, to be quite careful in correspondence as to what you put in issue. So obviously it's perfectly proper to say that we're not admitting that the covenants are enforceable. That isn't threatening to breach them. And that is something that an employee should be saying in correspondence, in response to a threatened application. But careful, because if you go over that line and effectively positively state that you're not going to adhere to them because you don't accept that they're necessarily reasonable, then that obviously would amount to a threat, and that would give the employer grounds to seek an injunction. And just rather obviously, mere suspicion isn't enough. That's the CEF and Mundy case, which again is a seminal case. And clouds of suspicion are not the same as cogent evidence of wrongdoing sufficient to warrant an injunction, and that's the Capita and Darch case. So just a reminder that suspicion isn't enough there. In terms of whether damages are an adequate remedy, this is a very interesting area for development, frankly, because I think it was thought really until the Plannon case that there was a sort of assumption that damages wouldn't be adequate for the employer and they would be adequate for the employee because ordinarily they would be capable of identification readily because it would be a defined period if they were granted from non-competing. So far as employers are concerned, it is generally considered that damages are not what an employer wants. Damages are usually unquantifiable and they're rarely, if ever, sufficient to provide the employer with an adequate substitute for an injunction. And I've just cited D versus P there if any authority was needed for that proposition. But the interesting development comes with the Plannon case a couple of years ago. And I've cited the paragraph 111 there, that there's no presumption that damages will be inadequate for the employer and adequate for the employee. I put a question mark there because of what the observations in Plannon were, that it was unrealistic to argue that damages were adequate for the employee on the facts of that particular case, simply because the employer was good for the cross undertaking. And in fact, the observation went as far as saying that except in cases of very wealthy defendants or where the claimant employer is offering paid garden leave for the whole period of the restraint, the argument has no traction, was effectively what was said in Plannon. And it would be risky, of course, for the new employer in the context of a non-compete injunction to continue to employ. So there was a real issue that the employee may be left without any salary for the whole period of the non-compete, because faced with an injunction in relation to a non-compete, a breach would of course be a contempt of court. So if you're arguing for an employee, then Plannon is definitely a relevant case to cite in relation to why damages are not adequate. So that then really leaves us with the balance of convenience, and I can see that we're coming up to 45 minutes. So I think there are some interesting developments in this area, and I've just cited, I think, half a dozen relevant factors that the court will take into account in relation to the balance of convenience. And I think the first two, speedy trials and delay, are definitely very important factors by reference to very recent case law, which has underlined the importance of speedy trials, for example, when considering the balance of convenience. It is the usual order in covenant cases. And I think for some time that may have been forgotten. I certainly will always put forward the prospect of a direction for a speedy trial in these types of cases. And it's definitely worth, if you're seeking an injunction, it's definitely worth getting some understanding from listing as to whether a speedy trial could be accommodated and when, because it is something that the court should consider at the balance of convenience stage. And any arguments about queue jumping and the effect on other litigants could be put to one side if you can say to the judge, well, actually, we checked and the court can accommodate a trial in 4 weeks' time, say. So Memo, Connect and Bewley is the most recent case that stresses the fact that ordinarily these types of cases cry out for an order for a speedy trial. And in fact, in jump trading, even where delay did defeat the application of an interim injunction, the High Court actually ordered a speedy trial in relation to the enforceability of the injunction, and that was upheld at the Court of Appeal. And one of the factors relied on was that they had checked whether a speedy trial could be accommodated, and it could. So there were no queue jumping issues there. And then Guy Carpenter, again, a recent case, High Court. But there, interestingly, the employee originally favoured a speedy trial, but by the time it was being fought out in court, they did a U-turn, and effectively their position amounted to delaying the final trial. And again, the High Court there found that it was a suitable case for a speedy trial order. City Site Solutions and Baker, again, citing Memo, that the case cried out for a speedy trial. And then sportsdirect.com, which might excite football fans out there, which involved supply of replicate kits to Sports Direct, where it was fought out in the Competition Appeals Tribunal, but still of relevance because the CAT refused the mandatory interim injunction that Sports Direct was seeking, preventing Newcastle United from effectively going elsewhere, supplying elsewhere. But it ordered a speedy trial. And in fact, it said because it had refused the injunction, it actually made the need for a speedy trial more urgent, and the Court of Appeal agreed with it. So that's one to keep in mind in terms of balance of convenience. Delay is the other issue that is normally cited in relation to balance of convenience. And I think it's worth reminding ourselves that the key is not delay in and of itself, but whether the delay is unreasonable, and then to consider the nature and consequences of the delay. So it's ultimately about what is just or unjust in all the circumstances. And that means that you need to have evidence of prejudice if you're going to argue that the employer, for example, has delayed and that has caused prejudice to the employee. And there I've cited Plannon, which is a seminal case essentially on delay because it was a barter relief and it was upheld on appeal. Not least because the employer had delayed some 7 weeks, I believe, in seeking interim relief. But by the time it had got to the Court of Appeal, and the employee had in fact started with the new employer, and that is key. By the time it got to the Court of Appeal, the employee had been in post for some 7 months. And so the Court of Appeal, in determining the matter, said that on any view, by the time it had got to the Court of Appeal, delay was fatal. And that's a very relevant case if you're looking at delay. Boydell, again, we referred to that earlier. There, the court actually found that a 2-month hiatus was not a bar because, in fact, the parties had engaged in sensible exchanges. And then jump trading, there it was a barter relief. You recall we dealt with that case at the start of this seminar. And furthermore, what prejudice that was relied on by the employee there was an atrophy of his skills because he would have been out of the market for almost 2 years, having regard to the garden period leave and the period of the non-compete. And the new employer was able to lead evidence on prejudice because it had assembled a team ready to start relying on the new employee being the head of that team. So there was clear prejudice there and delay was fatal. So to sum up on delay, correspondence is a good thing. It's good to promptly engage in any substantive arguments or any proposals for settlement, but do not allow the employee to start at the new competitor because that will definitely play into delay being unreasonable. And don't wait until the end of the notice period to raise issues about injunctions. Raise it early on. And then we've run out of time, but I think the handful of bullet points on the last slide there in relation to balance of convenience are also worthy of note because they have been raised recently in the cases that I've cited there. And I've touched on the context and the nature of the contract in question. So it's not a binary situation where if a covenant appears in what seems to be a commercial agreement that the court won't scrutinise it as much as, say, an employment contract. Essentially, the court has to look at the substance of the arrangement in the contract, and some commercial agreements are more akin to contracts of employment, and the court then has to scrutinise it carefully and weigh up the arrangement and determine where it fits on a calibrated spectrum. Commercial arm's length, equality of bargaining position on the one end of that spectrum, and then on the other, the employment context with no equality of bargaining position and a fait accompli. Notice periods are also relevant. I've referred to the Quilter decision there. It may be relevant to consider if you're faced with an employer who is seeking an injunction for what appears to be an inordinate length of time, to consider whether or not the employee was subject to a short notice period, because the length of the period of notice can be an indicator of unreasonableness. So, for example, if you have an employee who is subject to, say, a 1-week notice period and is faced with a non-compete for 12 months, then that could be an indicator that that non-compete 12-month period is unreasonable. And then finally, inequality of bargaining power. And as I said, I referred earlier to this recent case of Dwyer. It is a franchising agreement case, but there the facts were extreme. There was no opportunity to negotiate, and effectively the inequality of bargaining power was considered to be a significant factor in determining reasonableness. And it may mean that the agreement is more akin to the employment agreement on that spectrum. So there it is, a fast canter through this field. But as I said at the outset, there's opportunity to ask questions in the chat feature. There's a feedback form. You're more than welcome to contact me by email or by phone through my clerks. Details will be on the slides and they will be sent out to anyone who's attended and provided their email address. Thank you for your time.